Look, I'm going to point out some uh, DOT fraud. You see right here in the red and blue, this is a case law. Alright. Now, for some of you that don't know case law, if there's a case that was presented to the appellate court or the Supreme Court, and they ruled in favor to the person who was being charged with a crime, or somebody who had sued somebody for a rights violation, and the courts rule in their favor, like this right here, for example, saying that the right to operate a motor vehicle with an automobile upon the public streets and highways is not a mere privilege, but it's a right under liberty, right? So they ruled that, and the guy won his case, okay? Doesn't matter what state you live in, because the appellate court and the Supreme Court are federal courts, okay? The appellate court is actually a Supreme Court, okay? You can take this case law, and you can go to any state in the United States, and you can win your case if it pertains to the same thing. Alright. So this right here's a case law, which was in Chicago. I think it's an appellate court on this one. Well, appellate or Supreme Court don't matter. Okay. Now, if there was a case law in a state court, then you cannot take that case law to another state, because states have different laws. But if you were to take that court or that state court case and present it in the same state, then you can win your case. But this right here is Supreme Court, appellate or Supreme Court. You can take it anywhere in any state in the United States, okay? Because federal is not just located in a certain area when it comes to appellate court or Supreme Court. Now let's get to the fraud. Now you see right there in the red where it says the right to operate a motor vehicle. And then you have brackets, or you have an automobile in brackets. Okay? Now what brackets mean, let's check that out real quick. This is the meaning of brackets. It's to put in a grouping. And it also is to indicate that something is equal. Okay? Like you see right down here where it says my sisters, right here. Mandy, Sandy, and Brandy. Okay? They're in the curly brackets or braces. Sure, it's going to be 3 different individuals, but they're in one grouping, an equal grouping, which is sisters. Okay? Right below it, you'll see variety of colors: red, green, blue, yellow, white, black. They're in braces. They're different, but they're all colors, right? Makes them all, they're in a grouping. They're not the same, but they are equal because they're all colors, right? So this is saying that a motor vehicle is an automobile. So we have a right to operate a motor vehicle, which you see right down here, right here. Motor vehicle, which is the definition, you'll see it right there, 18 U.S. Code 31. It is a legal definition. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers, and property or property of cargo, used for commercial purposes on the highway. So basically, a commercial motor vehicle, something that's running in commerce, like a semi-truck that has a DOT number on it. Now, if you get a semi-truck that don't have a DOT number on it, that's not commerce. You can drive that truck without a CDL, believe it or not. They only require CDLs if you drive in commerce. And the only way that they can recognize a truck being in commerce is if it has a MC number or a DOT number. Okay? But through case law and through the privilege and immunity clause, you don't need a license to drive, whether it's in conveyance or commerce. Because in the privilege and immunity clause, it does recognize that even through commerce, you have a right to travel. Now, the courts try to twist this around and say that in commerce, you are driving. But if you're not in commerce, but you're in conveyance, like driving a car to and from work, or just basically if you're using a vehicle not to use, or not making money with that vehicle, that's conveyance. That's traveling. They will say that's traveling. Not driving, but traveling. Okay? They try to twist it. What they're doing is they're making deprivation of rights in the color of law. They are violating people's rights to travel when you're driving in commerce, telling you that it's a privilege. No, it's not a privilege, because in the privilege and immunity clause, it recognizes commerce when you're driving in commerce that you're traveling, and it's a right. So they're saying that commerce, when you're driving in commerce, it's a privilege. No, it's not. Now, commerce itself is a privilege, but when you're driving, aka traveling, while you're operating in commerce, that's a right. They cannot strip that from you. So with that said, all these regulations right here, yes, include, look, right here, invalid regulations. Let's start right up here where it says, right here, it says, driver, driving, motor vehicle, motor carrier are travelers. Traveling is a right and not a privilege under liberty, whether in conveyance or commerce, as recognized in the privilege and immunity clause, which cannot be restricted, regulated, hindered, or denied. Now, according to the APA, which is the Administrative Procedure Act, Public Law 49-404, Section 12, it says nothing in the act shall be held to diminish constitutional rights, and if it does, it becomes invalid. Right? So, all these right here become invalid, and it's not just limited to this. I'm still building on this document, because I guarantee you half of the CFR 49 regulations is going to be gone. They're invalid. Just like controlled substance and alcohol use in testing. Okay? That's in the CFR 49 regulations. It's in part 382. Let's check out what it says on the FMCSA website about that. Hang on a second, let me bring it up here. Now, if you see right here in the pre-employment, it says an employer must receive a negative drug test result before permitting a CDL driver to operate a CMV. That's code. That's in the CFR 49 Regulation Code 382.301. That's invalid, because as you see right here, driver to operate a CMV. Okay? That's invalid. What they're doing is they're telling the employer to violate people's rights by putting a regulation in place that already violates people's rights. That's tyranny. That is illegal, a violation of constitutional right and constitutional law. Because as you see right there, it says driver to operate a CMV. But in this case law, right here, it says the right to operate a motor vehicle. And if you've seen the definition, a motor vehicle is something used in commercial, and commercial is commerce, right? So it becomes invalid under the law, the APA, which is a law which governs agencies and judiciaries to make rules, regulations, and executive orders, and so on. But nothing in the acts or the applications, which applications are these rules and regulations, are not to be held to diminish constitutional rights, and if it does, it becomes invalid. And the government don't get to pick and choose what's invalid. We do too. Because if we know it's invalid, we don't have to abide by it. And if they want to try to oppress law against you for not obeying what is unconstitutional, then press a civil suit. You have a right to do it. But you see right here, traveling in red, all these right here are violations of constitutional law, and every one of them is invalid, including the DOT physicals. Even through now there are state laws out there that say that you have to have a DOT physical before you can get a CDL. That's invalid. I done contacted my state legislator and told them they need to remove that. And don't be trying to twist it like you guys like to do and tell me that I'm wrong. But I figured I want to bring this all up to your attention. Peace out.